home straight before the weekend.
It is the home straight, it is, and I hope to be really quite quick. This is very little left, given we helpfully trespassed over a huge amount of the topic before lunch. So there's very little left. There is really, I just wanted to
Can you just explain to me why the parties have decided to separate out Section 50 from equitable compensation more generally?
Because I think it sat more generally happily with injunctive relief, given it was in lieu of injunctive. And the same questions going to jurisdiction and the meaning of power and jurisdiction apply to Section 50 as they do to injunctive relief. So those two topics were the most closely tied.
Okay.
It is, of course, relevant to equitable compensation and what relief is available in the absence of equitable compensation, so it fits that way. But the argument sits more happily in whether Section 50 is available with injunctive relief.
Right, and we're going to, well, I remember we're definitely going to be sitting at 11:30 on Monday.
Very good, my lord. My lord, yes, Mr. Hancock makes the other point, they were differentiated because they are separate appeals. The states are the appellants on equitable compensation. It's a respondent's notice point for the club, and they're the appellants on the injunctive relief. Which isn't to say that you can't deal with the topics as most logically come up, but technically they are.
No, it's all right. Anyway.
But that wasn't really driving the analysis as I understood it. but my lord, yes. So I mean, obviously equitable compensation ought to be finished today. There's a truncated day available on Monday to deal with injunctive relief in Section 50. But I mean, subject to the court, it may be necessary to drift into Tuesday morning to finish injunctive relief in Section 50.
Yes.
But I don't anticipate what the Lordship has said.
Yeah, I completely understand that, yes.
In which case, just where I wanted to start, which is, so the court has the material before it in terms of the ground of appeal issue. I was just going to show the court the arbitration claim form, which it contains the ground of appeal from the arbitrator to the High Court. And that's in core bundle, please, page 966, tab 42. Yes, tab 42, if anyone's using tabs.
Yes, there's an equivalent, of course, for Spain, isn't there?
My lady, yes.
So where are you? Core bundle?
Page 966, tab 42. I'll just ask my junior just to find the equivalent for Spain.
It's a tab 38.
Mr. Thompson says it's tab 38.
Sorry, it's tab 40 for Spain, page 9.
Okay, I'm just going to do this one. Sorry. Could I just let's just stick with the document we're at, please, which is 966. This is France. And one sees under number paragraph 2, there are 4 grounds, and ground 2 is the one that concerns us presently on equitable compensation, which is really very similar, bar the final sentence, to what I'm taking the court to, or the appeal to this court. And importantly, it says, or whether equitable compensation is otherwise available in those circumstances, which does tie it. It's a broader question as simply a binary yes/no to equitable compensation, and it does allow this court to take the circumstances of this case into account. And I think the equivalent for Spain is at tab 40 at page 947. 948. And it's ground 4 at the bottom. Yeah, I've got it at the bottom of the page on 948. So that's expressed in different terms, but my solution really comes to the same thing. And for the court's note, just so you have it, Spain's ground of appeal to this court is at tab 25 of the core bundle, page 474. It's the final ground on 474. Which then goes over to page 475.
Yeah.
So those are the limits of the matter under appeal. If I may, going back to the argument where I left it before lunch,
Yep.
which was the 256 claimants. What I do propose to do, and you might say it's a bit of a jury point, is to show the court the execution order from the Supreme Court of Spain in this case, which is actually the judgment which is subject of or the application for recognition, which is at issue, and it makes the point as to the numbers of different parties involved and the amounts being awarded, and it really that Spain and France are just simply two parties extracted from what has already happened. And that order can be found in its supplemental bundle. This is on the CJEU appeal. It's tab 12 and it's page 552, I think, is the first page of the document. My PDF is called Full Supplementary Bundle. That helps. So there it is, 552. If you could just
The
go
Provincial Audience Court.
to my lord, yes. And if the operator could just go to the top of the page so we can see what that is, so we get the heading in, great, the enforcement hub. And one sees there the list of parties involved in the case, and on the claimant side, I could ask the operator to go to the next page, please, page 553. One sees it goes on the sheer numbers of people involved. I counted them up, there's 256. If I could then ask you to go to page 559, please. What happens at this part? This is the operative, I hasten to use that word, part of the order, which sets out each claimant party and the award of compensation made in favour of each claimant party.
Yeah.
Nothing has come up on my screen. I suspect something might have gone wrong. All the screens have gone off. But my lords, my lady, do you have that available
Yes.
on your own screens?
Yes.
Okay, I'm just, forgive me, I'm just checking.
This one flashes on and off
Oh, does, oh right, okay.
of its
okay.
own motion.
Or on in which case, page 559.
563 in the electronic.
I'm grateful. One sees at the start the Spanish state is the first claimant, and then one has the award there. But then as one goes down, one has the regional government of Galicia, then one has the French state, Pescamar, SL, and then we come down to the individuals who are claimants. Lucia Anon Verdez awarded 1,859 euros. Juanita RK Cassis awarded 1,859 euros. And if one just scrolls down through the pages, one sees, for example, at 567, various different French municipalities as claimants. There's Vendée City Council, for example. Page 502, we have the Biarritz City Council. And there are many, many individuals, municipalities, businesses, other organisations, interested parties who are listed as claimants and who are awarded wildly varying sums of compensation by the Spanish Supreme Court. Very small amounts right up to the amounts awarded to France and to Spain. So all in, and this is the order of which recognition is sought in these proceedings, 256 separate claimants in the Spanish proceedings who were granted compensation. And so from an English law perspective, this is 256 separate arbitrations. All of these claimants, when they commenced proceedings or proceedings were commenced for them in Spain, became bound to arbitrate this dispute, the civil claims against the insurers. And so what is being proposed this court do is to extend the law so that the equitable obligation to arbitrate results in equitable compensation being available against this list of people. And that would be equitable compensation in the amount of the insurer's costs of going to Spain and defending the proceedings and equitable compensation in an equal and opposite amount to all of these amounts listed out by the Spanish court. Now, the club hasn't taken proceedings against all these people. They've just gone for France and Spain, picked off the big two fish. But there's no reason at all, as a matter of principle, why exactly the same result would not be available as against all of these different claimants. And part of the difficulty with the analysis that is put forward is that if one is prepared to grant compensation on the basis of an obligation equivalent to contract, then there is going to be very little, and one is simply assimilating that within contractual principles, then damages are, in effect, going to be available as of right if you are applying a contractual analysis. There's going to be no principled basis upon which to distinguish granting damages against France and Spain and granting damages against everybody else, which is one of the great difficulties with equity taking this line. Section 50 would be different because the court has a far greater discretion available. But if one is pursuing a contractual analysis as a matter of right, the right sounds in a remedy, the remedy is damages, then these are the consequences of the court granting this form of relief. In this case, and there'll be other.
Why shouldn't there be a discretion here as well?
Because there'd be no principal basis, my lord, upon which to exercise it. There's no distinction in principle. But there's no unconscionability. In terms of unconscionability, what one has at this stage is English law taking a particular view, civilian legal systems taking a different view, the CJEU taking a different view. The law's not been static since 2002, and we are now in a position of fairly acute conflict between what the CJEU is doing in Assens-Haven and in this case, and the direction that English law is going. And so this is a conflict that is not going to go away. But in my submission, awarding equitable compensation in these circumstances is not the answer. You've got a conflict between these two legal systems. In my submission, really, the way to resolve it is by way of dealing it through the recognition and enforcement process, rather than by awarding amounts of equitable compensation against people. If you don't like the judgments coming in, and there has to be a way of addressing that. There's the regulation in this case, and there probably won't be a great deal of, well, many cases after this, because we're outside of the EU. There'll be the rump of cases that already exists. And in other circumstances, now we're out of the EU, one has, of course, I think it's section 32 of the Civil Jurisdiction and Judgments Act, which says that a judgment obtained from a court of overseas in breach of an exclusive forum clause will not be offered recognition in this jurisdiction. So that is, if one likes, part of the answer, although not the complete answer, because when direct action claimants go and get their awards of compensation abroad, they'll have their judgment. Insurers here in the position of the club would go and start an arbitration against them, get an arbitral award, if the law stays as it is, with equitable compensation in an equal and opposite amount and for their costs. That may not need to be translated into an English judgment, maybe it will, because the direct action claimants, if they wanted to enforce, would have to take their judgment probably from their home court and port it somewhere else. And then insurers would have to use either an arbitration award or a Section 66 judgment like Mr Justice Hamlin's, or an enforcement of the equivalent of Dame Elizabeth Foster to use it as a set-off in the foreign court. And that's how these awards of equitable compensation will be used. And so there is a risk, if I can put it like that, or what is likely to happen is that awards and the Section 66 judgments built upon them will be used as a sort of neutralising agent, if you like, in relation to foreign judgments, but also their use overseas potentially. So it has fairly extensive implications. But really that is all grist to the mill for my submission, that equitable compensation ought not to be granted in this type of case. And in my submission there is let me take a slight step back. Part of the difficulty and the clash which is occurring in relation to direct action statutes is because of the nature of the conditional benefit principle. The EU law is looking at the relativity of the arbitration agreement and it not having effects with third parties. English law doesn't see it in that way. And the trouble is being caused because arbitration, which is a private form of dispute resolution and potentially expensive one, is being imposed potentially on people who have no good reason to suppose that they are party to or obliged to arbitrate. It's one thing where you've got states or big commercial enterprises, but it's completely different, or not completely different, but it's going to make a difference in practice where you've got ordinary people availing themselves of their local statutes or smaller businesses or whatever it's going to be. And in my submission, there's a qualitative difference between a person who signs a contract voluntarily and a person domiciled abroad who takes advantage of a right given them by their local law. Now, English law is ignoring that right. That's its choice. That's the conditional benefit analysis. But in my submission, there ought to be a limit on the consequences and the liabilities being imposed in this type of case. And equally what I say in relation to unconscionability, which, as I said, looms large, is that you've simply got different legal systems prioritising different interests. The Europeans have an entirely legitimate point of view to project and injure parties and to give direct rights of access and not to force them to enter into a private form of dispute resolution. English law has a completely legitimate interest in trying to uphold contractual bargains, even as against people trying to take advantage of them without, as you would say, respecting the arbitration.
But, I mean, I think your point is, if I may say so, obviously well made. What's the solution if you're wrong about there being an availability of equitable compensation?
The solution is the solution which has been applied until really sort of this point in time. Injunctive relief is available if it can be justified.
No
If it can
equitable
be persuaded to
compensation.
no equitable compensation.
And what if you're
And
wrong
we're only
about
looking at equitable compensation because Section 50 isn't available here. So in a way, equitable, the club is trying to use equitable compensation or shoehorning, trying to extract a remedy from equitable compensation, which it just wasn't sort of designed for and has ever been used for, to get around the difficulty in this case.
But why is an injunction not available against Pablo Luis, somebody who's one of those claimants?
It is subject to the court being persuaded there's a good reason not to grant it.
So
That's
why
the
is
state of the law.
why is equitable non-compensation not available against Pablo Luis?
Because it goes further. Because it goes further. Because it imposes a monetary liability on Pablo Luis.
Yes, but under Section 50, I mean.
But under Section 50, the court has a discretion whether to do it or not. So if the court thinks, I'm not going to impose, it's not fair, I'm going too far beyond my reach here to try and reach into some Spanish proceedings and impose a liability on Pablo Luis or grant an injunction against Pablo Luis,
Yeah,
I'm not going to do it. And the court would be able to take into account the entire circumstances of the case and say, this is just not what I'm going to do. The court would have to develop principles on when they would either grant such injunctions.
What I'm suggesting to you, Ms. Dilmont, is that there isn't any reason why equitable compensation shouldn't be in principle available for breach of an equitable obligation established by this court, but that it should not be automatic. There should be a system of principles developed as to when it will be granted. And what I'm asking for your help on is what are those principles? I fully understand that the no damages equitable compensation should be awarded against Pablo Luis, if that was his name, as one of these claimants.
Yes.
But why?
Well, the difficulty with it is that there will be no principal distinction. There's no, if you're prepared to grant it against France and Spain, you're prepared to grant equitable compensation against Pablo Luis on this analysis of substantive equitable obligations equivalent to contract. That's what compels the court to grant equitable compensation against Pablo Luis. Under Section 50, discretion is at large.
So why should discretion not be at large for the breach of this equitable obligation?
Because it's difficult because of the reasoning which is being used to sustain or create the equitable obligation. It's difficult to see what the discretion could be. If there is an obligation equivalent to contract, we're applying contract here. If you breach a contract, you're liable in damages. And that's what the cases for breaches of exclusive forum clauses address, and they give specific forms of relief in relation to them.
But Ms Dilmore, doesn't the premise for granting an injunction is a breach of an equitable obligation? So you've got to face the fact that the starting point is this equitable obligation that's been breached, and so far the remedies granted have been injunctions and declarations. But as the Master of the Rolls said, it doesn't follow that if there is a financial remedy, this being equity, all remedies are traditionally discretionary. Why should it follow that a financial remedy would be automatic?
Because of the logic that is being used, because of the reasoning which is being used to impose and define the obligation.
Are you referring to the reasoning of the arbitrators? We're trying to understand what the reasoning principle should be.
I'm not sure it is the reasoning. I mean, there are passages in some of the authorities that you've shown us that suggest that there is, if you like, as my lord put it, an equiparation between the common law position, contract, and treating somebody as if they were parties to it in some of the cases. Not sure that's necessarily the right analysis or the only analysis that can be applied, because if you've got it, on the one hand it can be said, well, you can't insist on rights that you might have which enable you to take advantage of an insurance contract without taking the burdens of that contract. But that's not quite the same thing as treating you as if you were a party to it.
No. But one would have to look and say, well, how are they not being treated as a party? Once they're bound and an obligation to arbitrate an equity arises, what then is the distinction between that third party and a contracting party? I mean, to date, it's not been possible to identify any. They simply become bound with the full rigour of the contract.
Well, nobody said that. All the courts have said is that there is an equitable obligation to arbitrate, and if they don't arbitrate and they bring proceedings in another jurisdiction, at that point they are in breach of that equitable obligation, whatever that means. Nobody has said what the consequences are, except that you may get a declaration and perhaps an injunction as a matter of discretion. Why should you not also, as night follows day, get equitable compensation as a matter of discretion, the discretion to be exercised on the basis of all the variables and different circumstances that you've described, thus making it obviously impossible to get damages against or equitable compensation against Pablo Luis, but potentially possible to get equitable compensation against a state that has tried, I mean, if these were the circumstances, tried to circumvent the arbitration clause, as the club would say you have, or France has. But I mean, that may not be the correct colour of the allegations, but that's what's said against you. But why is it not, in principle, open to the court to exercise their discretion on grounds of unconscionability, of conduct, of the appropriateness of the award, how much should be awarded? I mean, I believe that Dame Elizabeth Gloucester awarded against you the costs of the Spanish proceedings, right? Now let's say the club's costs of the Spanish proceedings. So let's say the club is not seeking that, but is seeking against Pablo Luis the costs of their coming to Spain to defend his claim, brought perfectly properly in his home court for damage to his property as a result of oil pollution from that ship, right? Let's say the idea that this court would grant equitable compensation in respect of the club's costs of going to Spain seems to me rather far-fetched, right, as a matter of discretion, because of the circumstances in which Pablo Luis brought his claim. Now, you say it's exactly the same for the state of Spain and the state of France. They're entitled to bring proceedings in their home territories and by their home coastline, as it were. But why is it impossible to say there is jurisdiction, but it doesn't apply here?
Because certainly with the reasoning of the cases to date, they have declined to, I'm not saying this is how this court would approach it, to date they have declined to confer any relevance to the fact that anybody is suing under a direct action statute. The means of accessing the arbitration contract is said to be irrelevant. What matters is the right.
They may have done, but we can't.
That's what the Court of Appeal has reasoned in Yusuf.
In what?
In Yusuf, Sepni Longu.
Well, you haven't shown us Yusuf, so you better do that.
No.
What does Yusuf say? Doesn't matter.
Yusuf was a direct action statute case. Hang on, if I just find my notes.
Where is Yusuf?
Tab 42.
Tab 42. Obviously, we all knew that. There's only 3,000 authorities.
Yusuf is tab 42 page on my electronic bundle 820.
Yes. Well, it's 831. Doesn't
Quite
matter.
close. Quite close. Yeah.
Now,
So
where did we find the relevant passage here?
I believe I'm going to go to paragraph 47, where the court, an argument was put to the court that there is a difference between an assignment type case and a direct action type case.
47.
46 starting, I believe, and going on to 47. Yes, 47.
But this is only the subsidiary judgment, because the lead judgment is given by Lord Justice Longmore. Anyway, Mr.
It was
Lewis.
Longmore and Lord Justice Morbick who gave the lead judgments in both cases. They both gave extensive judgments and reasoning coming to the same view.
Okay. Mr. Lewis sought to distinguish the position of the person who
Yeah,
becomes...
I should say Mr. Hancock helpfully this time. I said 22 to 35 is Lord Justice Longmore.
Yes.
Yes, but I think the clearest exposition of where the court says it doesn't matter how you access the right is 47, and this builds on Mr. Justice Morbick as he then was his analysis and through transport number 2.
Can the case be brought up on screen? Because I just lost my laptop for a moment.
It's page 838.
Or 849 if you're looking at it.
Luckily, the operator is on my
You got it.
numbers,
No,
I think, so I think it is right to say 838.
It's all right. I'll have a
Authorities Bundle B.
I mean, I don't see that paragraph as saying any more than you've got an obligation.
Well,
47's a bit more trouble.
I think it is, and
So what? Just point me to the bit that you say goes beyond that. So,
Between E&F, as was made clear in the J vote of the arbitration, he says, in my view, there's no real distinction
yes,
between the position of a person who becomes entitled to enforce by virtue of an assignment, or a person who obtains a statutory right to recover damages direct from an insurer. And then he says the arbitration agreement becomes binding on the claimant.
Yeah. If I could also ask my lord to read 48 and 49, where he goes on with that analysis.
But is that ratio?
Well, I think, yes, because both Lord Justice Warbeck and Longmore, this is the most expansive articulation of it.
But he's
yes.
explaining why the right exists, isn't he? He's not addressing the question of remedy.
He's analysing when considering in the context of granting an anti-suit injunction and what the applicable issue should it be the contractual angelic grace principles or the vexation and oppressive principle. He's selecting the contractual test. And Mr. Lewis said, well, it's a direct action case, this is different.
He does appear to be saying directly that the basis for the court's
Yes.
intervention is the same in each case, and intervention, of course, in this case is by means of injunctive relief.
Yes.
And so if the basis for granting an injunction is the same basis as there would be for granting equitable compensation, I see what you say, that the courts have
Yes.
already said there's no distinction to be drawn between the two situations.
Well, my lady, yes, that's why I'm saying it's not, with the reasoning which has been adopted, it's very difficult to find a principled way of distinguishing the position. Why the
Well,
position?
the principal way, sorry to interrupt, but I don't think...
Well, I mean, not just in terms of how the authorities have
I don't
analysed it.
completely agree. I think the principal way of distinguishing is that you also always have a discretion as to the grant of an injunction.
Yes.
And so what is the difference between saying the foundation of the grant of the injunction and therefore equitable compensation in default, if appropriate, is a discretionary one, but it's a right. The right has been has arisen, but it's for the court to decide A, whether they grant an injunction, and B, whether they grant equitable compensation, which is discretionary.
There is always a discretion to grant an injunction, but that discretion, depending on the test that's being applied, it becomes really very narrow in terms of the leeway the court actually has not to grant an injunction. Well, under angelic grace principles, I've got a contract, I've got an exclusive forum clause, angelic grace, and the subsequent authorities say, I get an injunction unless there's good reason, unless you're able to show good reason not to grant it. And it is not easy as a matter of practice to bring yourself within that good reason if there's an express jurisdiction clause, an exclusive jurisdiction clause. So one would be, taking the analogy of injunctive relief, how narrow EDE or the narrow grounds for trying to say to the court, as a matter of discretion, you shouldn't be granting this injunction, will be in exactly the same place under equitable compensation. What is the narrow chink through the door that you're going to have to persuade the court not to grant equitable compensation against you in this case?
Well, doesn't
when you're otherwise
doesn't the distinction come at the end of paragraph 50? I've just been reading on, because as my lord says, the absence of a distinction between the two camps, if you like, of people, the assign or subrogated party on the one hand, and the direct action party, all of that discussion is in the context of whether or not there is a foundation, if you like, for the potential of granting equitable relief, in other words, jurisdiction to grant it. But if you look at the end of paragraph 50, that's really addressing the question of why you would grant an injunction. And in that passage, Lord Justice Morpick is saying it's not a case in which there's a breach of contract, but nor is it a case where you're trying to say that the proceedings in Turkey are vexatious or repressive, very much more the character of the former than the latter. And then he's talking about the nature of the right which equity is being asked to protect. So that is very much the language of discretion, it seems to me, that's the passage which is saying, well, we might not draw a distinction between them in terms of the foundation of our jurisdiction, but when it comes to exercising it, there are different matters that come to the fore. And in this particular case, we're looking at whether or not it's right to protect the for equity to come in and protect this right by way of an injunction. And that depends very much on the nature of the circumstances that are applying.
Because at the end of 51, what he says, in each case, sufficient grounds for intervention are to be found in a commencement of proceedings
Yeah.
contrary to the terms of the arbitration agreement.
For an injunction.
For an injunction.
Well, normally.
I mean, he's
but-
not dealing with equitable compensation at all. I mean, this is purely looking at injunctive relief.
Now, I think the point I was struggling to make, Mr Ilmott, is that I think that the distinction, or the lack of distinction between the two camps, as I put it, comes in at an earlier stage of the analysis. It doesn't stop it coming back in again at the stage where you exercise the discretion.
Well, you know, but I agree. But that, in a way, was hence why I was saying about I know it's an injunction, but angelic grace principles. You then have to try and bring yourself within the good reason, and that's called. That is the. It's not just a discretion. There are principles on which you work out what the good reason is, but if you can't show a good reason, then the actual discretionary element is it's difficult to see where it exists other
Well,
than
a
good
good
reason.
reason may be that there is a right to start the proceedings in your own jurisdiction as a matter of right of action, and it may well be that there's a good reason to grant an injunction at the stage when it's not got any further than that, in order to stop the mischief of there being two conflicting decisions in circulation. But once that particular ship has sailed and you've got the position where there is a conflict, there may be a remedy in terms of saying which one of them prevails, one way or the other, but compensation wouldn't necessarily flow from the exercise of something which is otherwise a right. I'm just thinking aloud, but that's one way of looking at it.
There would be some form of discretion available to say, right, no, this is equity. I've got to.
It might be a justification for saying, in the case of Luis, we're not going to give up equitable compensation because all he's doing is enforcing a right that he's been given by his local law. You might say, well, that would apply equally to the club, but to the state. But
Well, I mean, that's right, because everyone in that order has gone and got a judgment from the Spanish court. And Luis is an extreme example because he's
Yes,
only
but
down
one distinction here is that there were actual arbitration awards against France and Spain.
Yes, that is the distinction in this
That's a major distinction, isn't it?
particular case.
And one of the things that troubles me about all this is that whilst, of course, we're not concerned with the interaction with the regulation, Mr. Pablo Luis's justification might well be the regulation. And where does that come into the account? Something I think I might have said at 10:35 on Tuesday.
Well,
Monday.
that's why I took it on the chin when I started my submissions.
Yeah.
Pablo Luis's right would come in as a matter of Spanish, in this case, domestic law, under the criminal statute. So he has his domestic rights, and the regulation then comes in really from a perspective of legal dependence and then subsequently recognition and enforcement.
I mean, the great
That's where
difficulty
that
is the one you pointed out, really, which is the collision course.
Forgive me, my lord, I missed
The
that.
collision course
The collision
that is
course.
being set between
Well, it is.
between the different laws.
It is.
But in the case of Pablo, if he sought to have the judgment in his favour recognised in this jurisdiction, there wouldn't be a conflicting arbitration award or judgment of Mr Justice Hamlin.
No, there wouldn't be, because the club hasn't gone and got one against them. But there could be. The club has not done it because they're not worried about the 1,000.
What we're trying to explore is
Yeah.
the possible different circumstances that might inform whether any principle should exist.
Well, that's right.
And there could still be a claim against him for an injunction
Well, that's it.
to
But
stop
or-
him enforcing here,
Well, that's right. Or equitable compensation.
or
which we've
equitable
done now.
compensation.
There's the awards here come up at an earlier point, but there's nothing to stop. Once he's gotten to the end of the process, an arbitration is commenced seeking equitable compensation. Don't bother with an injunction anymore. Too late.
You can
Although you
imagine
get an
that-
anti-enforcement injunction, which is what Dame Elizabeth Gloucester did. But you get to the end, and I'm not going to bother with an injunction because it's gone so far, but I'd like equitable compensation, please, in equal and opposite amounts, so I can set that off if he comes over here or goes somewhere else.
You can imagine the Court of Justice having a minor heart attack at the thought of our courts, even if we were, well, if we were members, even worse, but if we're not members, probably nearly as bad, as awarding equitable compensation for asserting your rights under a regulation.
Well, I mean, that's fine, but that, keep going down this route, it is just going to create a real mess. But it's not only EU-based claimants that are the concern. The regulation is EU-based claimants, but this is going to apply rather more broadly.
Or direct rights of action apply in all sorts of places. I had a case where it was in Costa Rica.
Exactly. Yusuf is Turkey.
Yeah.
They apply in many civilian
almost every civilian. Yeah, I had a case about Japan.
Yeah.
Yes. Well, I mean, that's right. So the EU angle, if you like, poses particular difficulties because you've got the supranational allocation of jurisdiction and recognition superimposed upon it, so that's a complicating factor. But the basic proposition that you've got people using their domestic rights, getting judgments abroad, which are susceptible to being neutralised by English law grants of equitable compensation in an arbitration and subsequently potentially enforced under Section 66, applies across the board. Doesn't have the added difficulties of the regulation and the recognition piece, but it has the rest of the complications in terms of what is the purpose of equitable compensation and, you know, what is an appropriate remedy to be granting against, I say again, third parties who are not parties to a contract. English law looks at it one way, other systems of law look at it another, and the problem is being caused by applying arbitration and binding people to arbitration who have nothing to do with the arbitration contract.
But we're bound by all this.
My lord, I know. I realise that, and I don't dissent from it, but it's a problem which therefore exists. But it is not a problem in my submission which therefore should be perpetuated by granting more extreme forms of relief. You try and get an anti-suit and injunction and see if they comply with that. You can get declaratory relief, and you can take your declaratory relief elsewhere if need be to explain to whatever foreign court it is that these people are acting in breach of an English law obligation to arbitrate. But in my submission, that really is the limit of, if you like, the territorial reach of this court when dealing with reality proceedings and people in other jurisdictions operating under other laws.
I think we've got it.
Yes. Unless I can assist the court further, those are my submissions.
Yeah. Thank you. Very helpful submissions, Mr. Yes.
May it please your lordship, may I first of all, on behalf of Spain, associate myself with all of Miss Dilnot's submissions and adopt them. My second point is my lord referred to an article written by my lord when he was merely Mr. Jeffrey Boss. It's in the Cambridge Law Journal. I don't know if you'd like to have it.
I'd love to have it electronically. I'll have it, actually.
Yes.
Did I say anything about this?
Well, it does. On a quick review of it, my lord, yes. There are a number of points where I might, but I thought you might like at least to have it with you.
Yes, in fact, I looked for it on my computer, but I was hacked about 12 years ago, and all the files that are older than 12 years have been corrupted. I couldn't find it.
If I say, my lord, Mr. Dickie Chan, who is at the back of the court, he has proved to me that anything is capable of almost instant realization by proper use of a computer. It's just so beyond me.
It's very good.
The third point is it's merely it's probably, I think it's probably a point my learned friend has made, but in Wolverhampton and the broad idea, injunctions are widely available without limit, and thus the financial, the ability of the court to give financial remedy is likewise without limit. There is no need to for recourse to equitable compensation because it's already been provided by statute. the problem in this case, the hole in this case, is that Parliament has provided by Section 13 that injunctive relief and specific performance orders are not available against states unless they have consented to the grant of such an injunction. So the only hole that is created is entirely the creation of a Parliament, and it's my submission that it is not the role of equitable compensation to fill a hole, not in the common law, but created by statute. And it would be, in my respectful submission, whatever may otherwise be the breadth of equitable compensation, it would be going too far to act against and indeed to controvert the parliamentary enactment. Unless I can assist your lordships further, your lordship...
Make it sound so simple, Mr. Young.
Well, I'm identifying the nature of the problem, my lord. It is almost ineluctably a problem which arises very specifically in this case, not in any other arbitration case, because there'll always be an injunctive relief available. And it's just this one case that equitable compensation is being availed to do exactly that which Parliament said you couldn't do.
So it shouldn't worry our little heads about it, really.
I wouldn't dare put it in those terms, my lord, but it is a problem. It is a problem. Is equity there to improve legislation? Unless I can assist your lord.
Yeah,
my lady further.
good. Mr. Hancock.
Yes.
Is it you or is it Mr. Thompson?
It is me.
It's you.
In relation to this, Mr. Thompson is going to be dealing with the question of injunctions.
Oh, right.
I'm dealing with this, and then I'm dealing with Section 50, to which I'll come back on Monday. But I will try and get through equitable compensation today.
Mm-hmm.
My lord, my ladies, if I can deal firstly with the manner in which the different arguments arise. And there were, as the court knows, 3 issues before the arbitrators in relation to the question of which remedy to grant for the state's breach of their obligations in obtaining the judgment against the club in Spain. The first was whether or not the club could be granted equitable compensation. The second, which was an alternative case, was whether the club could be granted equitable damages under Lord Cairns's power in Section 50 of the Senior Courts Act in lieu of an injunction. That second question gave rise to 2 sub-questions. Firstly, does a court have power to grant damages in lieu against a state, even if it could not grant an injunction because of the limitation in Section 13 of the State Immunity Act? Because if so, there is or should be no question that a tribunal can do the same. Secondly, did the tribunal have power to grant an injunction against a state, such as Spain or France? If the club was right about this, and again, there can be no question that the tribunal had power to grant damages in lieu, and the states had sought in their skeleton argument to add a third argument, namely whether an arbitrator has power to grant Section 50 damages at all, but that point has been abandoned by the states, and therefore we need not trouble your lordship and your ladyships with that. The third aspect of remedy was whether or not the club could be could be granted an injunction restraining the states from enforcing their judgment. That argument was and always has been a subsidiary one, because as my Lord the Master of the Rolls said, as in most commercial cases, this case is all about money. And the real question, therefore, is the club entitled to compensation, whether by way of damages or equitable compensation, to compensate them in respect of the costs of proceeding in Spain in the quantum proceedings, and secondly, to compensate them in respect of the consequences of the grant of a judgment procured in Spain in breach of the obligation declared by this court to arbitrate that claim. Now, just in passing, a quick outline of the way in which the various different points interlock with one another. The human rights point I can deal with briefly, because in a sense the human rights point is a subset of the appeal that we've been dealing with over the last 3 days. It's an alternative ground for resisting the enforcement of the judgment. That's an aspect of the Brussels appeal. Secondly, in relation to this appeal, then there are two aspects in which it would remain of relevance, even if the states are wrong, or Spain in particular is wrong, on the Brussels appeal. And those, because obviously if Spain is wrong on the Brussels appeal, then it won't have an enforceable judgment in this jurisdiction. And so there'll be no question of the club having to be compensated for that judgment. But what it will still have is a Spanish judgment which it may seek to enforce elsewhere in the world. And if it did seek to enforce that judgment elsewhere in the world, then the club would need the remedy by way of compensation to compensate it for the wrong on the part of Spain in getting the judgment in Spain. And the second is the point I've already mentioned, that's to say the costs which the club had to incur in mitigating its loss at the quantum stage of the Spanish proceedings. Then, if I can turn briefly to the manner in which the issues were resolved by each of the two arbitrators. In front of Sir Peter Gross, the arbitrator awarded equitable compensation. He also awarded an indemnity by way of Section 50 damages on the footing that he was allowed to award an injunction against a state, and therefore, because he was allowed to award an injunction against a state, he could give damages in lieu of an injunction. He refused, as a matter of discretion, to grant the injunction, but he did grant Section 50 damages. Spain appealed.
Sorry, just on that, the amounts of the equitable and compensation and the damages are interchangeable for.
They are, and as has been said, as Ms Donald has very fairly said, then the principal award is by way of an indemnity.
Yes.
Because effectively what has been awarded by the arbitrators is an indemnity in respect of any amount that Spain recovers pursuant to the judgment. Spain appealed to the learned judge to set aside the award of Sir Peter Gross under Section 69. It did so on 4 grounds, which are set out in the judgment below at paragraph 40. The 4 grounds are essentially as follows. I'm not going to read paragraph 40 to the court. It's worth just looking at it as a summary, but the first 2 grounds were effectively Spain seeking to argue that it wasn't under an obligation to arbitrate and it wasn't in breach of any obligation to arbitrate. And it based those arguments on the judgment of the Court of Justice for the European Union. It said effectively, Assenshaven means that the arbitration agreement wasn't binding on us, and therefore Sir Peter Gross doesn't have jurisdiction, and in addition, then we are not in breach of any obligation. Those 2 grounds were dealt with by the judge, who dismissed those 2 grounds and refused permission to appeal on both.
Which numbers are they? 1.
They're grounds 1 and 2, and the judge deals with them at paragraphs 305 to 314 of his judgment. So the reason for my taking the court to...
Sorry, I'm a bit behind, really. You've taken us to paragraph 40 of Butcher.
Yes.
It sets out the 4
the full grounds.
errors alleged by Spain.
Yes,
The judge rejected 1 and 2
yes,
and didn't give permission to appeal.
that's right.
So we're dealing with 3 and 4.
That's right. And the only reason for my making the point is that by reason of 1 and 2, what your lordship and your ladyships know is, firstly, there was an equitable obligation to arbitrate, and secondly, there was a breach of that equitable obligation. So we're only now talking about the appropriate remedy for that breach.
Yeah.
3 and 4 were equitable compensation and injunction.
And you're going to say that you thought you were simply talking about whether or not equitable compensation lay or not.
That's a slightly different point, my lord. My point at the moment is simply that there's no question but that there was an obligation. Actually, that was determined back in 2013 and 2015 by Mr Justice Hamblin and the Court of Appeal. Mr Justice Butcher, in the face of an argument by Spain that, in the light of the judgment of the Court of Justice, that it was not in fact under an obligation.
What are the references to Hamblin and Court of Appeal to that determination? Which paragraphs?
Well, so Mr Justice Hamblin's judgment was all about whether or not Spain was under an obligation to arbitrate.
Yes, where does it say though? Which paragraph is it? Just for my note.
The exact paragraph, my lord. And the Court of Appeal obviously said the same, upheld Mr Justice Hamblin's judgment.
Does he describe it as an equitable obligation?
It's paragraph 82, and I think Mr Thompson reminds me, in fact, he describes it as a contractual obligation in that paragraph. But that is where he's dealing with the characterisation issue. And so there, actually, he's looking at the distinction between, on the one hand, a contractual right governed by English law, as opposed to a right under a direct action statute governed by the law of that direct action. And he holds it's a contractual right, properly so characterised, as a matter of English law, and English law governs characterisation issues. And then in paragraphs 83 to 94, he deals with the question of whether Spain is bound by the obligation to arbitrate, and holds that they are. And in the context of the State Immunity Act, there is an extensive discussion of the State Immunity Act in Section 9, in paragraph 126 and following, where he considers cases like the J. Bowler and the through transport litigation and yes, and he adopts Mr Justice Moore-Bick's characterisation of the question in the through transport case, where Mr Justice Moore-Bick effectively says you become a party to the contract by virtue of making your claim on the insurance. So when we come back, as I will do, to the question of consent, as has been referred to, then the moment at which you signify your consent is the moment at which you make your claim on the insurance. We know that from the Atlantic Confidence, because if you never make your claim on the insurance, you don't become bound by the relevant arbitration or jurisdiction clause. but at the moment that you do, you signify your consent to be bound by the jurisdiction or arbitration clause. My lord, my ladies, I'm getting ahead of myself. I'm just trying to set the scene for the moment. I will come back to the questions that you've asked my learned friend in relation to, in particular, the difference in the position of the fishermen and the states. And just to give you a trailer in relation to that, the difference is really twofold. One is that the states, having made their claim, were then the subject matter of an arbitration and an arbitration award and judgments confirming the arbitration award. And the breach that they committed was in continuing with the Spanish proceedings in the teeth of the declarations that had been made in this country, saying that they had to arbitrate those claims. The second differentiating factor between the states and the individual claimants, and obviously I accept the point that's made, that is to say that as a matter of analysis, then the position of the individual claimants is exactly the same as that of the states. As soon as they actually make their claims, then they are equally bound by the obligation to arbitrate those claims. It doesn't, of course, follow that if they breach that obligation, there is automatically a right to compensation for that breach. And as my Lord the Master of the Rolls has said, it's always a question of discretion.
Is this your second point?
Yes.
This is actually the second out of 3 points, so with apologies.
What's the second differentiating feature?
It's the second out of 3 differentiating features.
Okay.
Because,
So what is it? That it's a matter of discretion?
yes, that's the second. So, and the third differentiating factor, and this is something that's important to bear in mind in relation to the widows and orphans submissions, is there is an international liability convention sitting behind all of this. And that is the Civil Liability Convention, 1969, and the Fund Convention. Those are internationally agreed conventions.
Which is the second one?
The Fund Convention.
These are the conventions that produced a lodging of 22 million, as I understand it.
That's right. Well, 22 million by the club. Then the Fund Convention is constituted by funds which are put up by oil companies. And the reason it's called the Fund Convention is because of the fact it's a fund which is administered by the International Oil Pollution Compensation.
And why is it a differentiating feature?
Because of the fact that in general terms, then as far as the fishermen are concerned and the amounts of the claims of those fishermen, those would be covered quite easily by this regime, which is a mandatory regime. It's a strict liability regime. So they would get their compensation pursuant to those conventions without the need to claim on the insurance. Here actually the differentiating factor is that Spain and France were making claims which were by far the largest claims against the club. When we get to the human rights part of the appeal, then I'll be showing you that the reason why those claims succeeded in the amounts that they did was because the Spanish court, Supreme Court, made findings that it shouldn't have paid. But just in relation to...
Like what? Why was it so big? I mean, 70,000 tonnes of oil sounds like quite a big pollution incident.
Yes, but there are limits, internationally agreed limits,
right,
which can only be broken in circumstances in which
There
the
is fault.
owners have been guilty of willful misconduct,
Right,
or
yes.
what is now called causing the damage intentionally and with knowledge that the damage would result.
Mm.
And the way in which that is interpreted as a matter of maritime convention is that the limits are set at a limit that is uninsurable. So the whole point is that by international agreement, then effectively you get, on the one hand, automatic compensation, strict liability compensation, which will be sufficient to compensate injured parties up to those internationally agreed limits. You can only break those internationally agreed limits in cases in which the owners have been guilty of extreme misconduct. And if they're guilty of extreme misconduct, then that will be because their conduct has been such as to be uninsurable.
But I mean, what we're talking about here doesn't have to be about oil pollution and cases in which the fund convention applies.
I quite understand that. I quite understand that, my lord. My point is simply in response to what I've called the widows and orphans point, which is that what is said is there are hundreds and hundreds and hundreds of individual claimants, and what your lordship and your ladyships are deciding will apply equally to those hundreds and hundreds and hundreds of claimants. My point is simply that in the real world, those hundreds and hundreds and hundreds of claimants will be receiving their compensation from the CLC fund and the fund
But
convention.
not in the Mariana Dam case, say.
No, but
Well, actually, in this case.
Sorry? Yeah. I mean, so there's plenty of cases where there are many widows, orphans, and possibly even fishermen damaged by an international incident where there is no international treaty providing for basic compensation.
no. But my point is that in this case, there is an international treaty providing for international compensation.
Yes, but why
And
does
it's
that lead to the conclusion that there is no equitable compensation
Well,
available against those people?
no, it leads to the conclusion that, and this is a discretionary factor, it leads to the conclusion that when one is looking, and obviously I'm saying that there is equitable compensation available to the club. The reason that there is equitable compensation available to the club is that as regards Spain and France, they did pursue their rights seeking arbitration. They did actually get arbitration awards and judgments from this court requiring Spain and France to proceed to arbitration. They ignored those orders from this court and carried on regardless in Spain, and thereby obtained the judgment.
So, I'm sorry, I wasn't completely aware that there were orders against Spain and France requiring them,
Well, there are declarations saying that they were obliged to.
declarations that they were
So,
obliged to.
and that's an order of
Who gave those? Was that Mr.
Justice Hamblin and the Court of Appeal.
Hamblin? They gave declarations.
They gave declarations.
Okay.
Yes. So, Mr Schaff gave the original declarations in the arbitration awards. Mr Justice Hamblin confirmed those declarations in his order.
Yes.
The Court of Appeal upheld
Yeah,
Mr Justice Hamlin's
I just didn't
judgment.
remember the declaration.
Yes.
You're right.
And I should make quite clear that Mr Stilnot fairly and correctly took you to the Airbus case, in which a declaration of breach was given. In our case, a declaration of obligation was given, because of course at that stage, then it might have been said that there was no breach, and certainly the breach was not nearly so egregious. Because if we go back to the point I made in relation to the Brussels appeal, well, once the Court of Appeal had rendered its decision back in 2015, then, as far as the club was concerned, that was that. Then the Spain and France had both been told, you must bring your claim in arbitration. And it was also the case that at that moment in 2015, we knew what the outcome of that claim would be, because Mr Schaff and Mr Justice Hamblin and the Court of Appeal had said then there is no liability because the pay to be paid clause, which is a condition precedent, as my lady Justice Andrews has correctly said, has not been satisfied. Ergo, then Spain and France knew perfectly well that if they complied with the obligation to arbitrate that they had been told they were under, then they would not recover any money, because they had been told that...
No, well, we get all that.
Well, you do get all that, my lord, and I don't want to...
But if I mean, what I'm not getting at the moment is why, if you're right, and there is a right to equitable compensation,
yes,
on a quasi-contractual basis,
yes,
you can stop, the court can easily stop by the application of readily discernible principles, granting the club's costs or part of the club's costs by way of equitable compensation against a fisherman.
Well, the answer to that, my lord, is the one that your lordship has already given, and that is to say that the remedy is a discretionary remedy. If actually the club were to say to Pablo Luis, or whoever it is, who's making a claim for €1,500, you must pay all of my costs of the defence of the claim, which amount to 800,000 dollars or euros or whatever.
Well, whatever, but I mean, it would be disproportionate, but that
it would be disproportionate.
But why
Whereas
is
if actually the position is that you are bringing that claim for equitable compensation against a party that is claiming over $1 billion against you, that would not be disproportionate.
Yes, but the principle, there has to be principle in the court's determination. If it were common law damages, right, the damages would follow. There would be no break. There would be no ability to say it's disproportionate.
No.
Right? You accept that?
Yes.
So it is...
Subject, for example, to questions of remoteness.
No, subject to remoteness.
So questions of like that.
But assuming there's no remoteness or causation issue,
yeah.
So why, when it comes to equitable, a breach of an equitable obligation, which is exactly analogous
yes.
to a legal obligation, does the court have this absolute discretion? And on what basis is it to be exercised? Is it unconscionability? Is it you give the award against big fish but not small fish? Or big fishermen and not small fishermen? Or what? I mean, how do we know?
Let me take it in stages, my lord. The answer is that it's an equitable remedy. And as with all equitable remedies, it is therefore discretionary.
Yeah.
The second point is that your lordship is quite right that at least one of the touchstones will be unconscionability. And in this case, the distinction between the little fisherman and Spain and France is that Spain and France were told in terms by the arbitrator and by the courts of this country that they were obliged to arbitrate their claims. In breach of those orders and declarations, Spain and France ignored the determinations of an arbitrator who had the relevant jurisdiction as declared.
Well, I get all that, but by the Court of Justice, and I know I'm conflating the timescale on which this happened,
Yes.
They were told that they were perfectly entitled to, notwithstanding
Yes.
the arbitration award saying exactly the contrary, they were perfectly entitled to enforce their judgment.
And my point, my lord, is, well, there are a number of answers. One is that the regulation doesn't apply to arbitration. And so the regulation is completely irrelevant to the question. The second is that in terms of the award of equitable compensation, then, as I understand Ms Dilnot's argument, she says, well, you could have got an injunction to stop Spain and France doing what they did in Spain. The answer to that actually is no, we couldn't, because Spain was within the EU and under the normal principles in the front comor in cases like that. Then mutual trust meant that we couldn't have gone and got an injunction stopping the wrongdoing carrying on in Spain. So then the question comes, in circumstances in which you cannot prevent the wrongdoing, because you're not allowed to do so, does that mean that you are not entitled to compensation for the consequences of the wrongdoing? And my submission on that would be that that would be doubling the injustice. Not only can you not prevent the loss from occurring by obtaining the injunctive relief, which Ms Dilnot says is the normal way in which this problem is averted, but you can't also recover compensation for the loss that you have suffered by reason of the wrongful conduct which you could, in other circumstances, have averted by virtue of getting an injunction. But
That's all looking at it through the lens of the arbitration. But if you look at it neutrally, there is a clear conflict of legal right.
I would submit no, my lord. That what is being said, it's being said actually that Ms Dilnot's point, as I understand it, it says, well, people under the regulation have got rights to bring their claims in their home courts. Those rights, in my submission, are subject to the obligation to arbitrate, which is out with the scope of the regulation.
Which applies to everybody.
But arbitration is outside the scope of the regulation. So you can't say, I've got a right to bring my claim, notwithstanding the fact that I've agreed to bring my claim not actually in my home court, but in an arbitration tribunal in some different place. Indeed, one of the ironies of this case is that, as I said to you, said to the court on the first day, then Spain and France said actually to the arbitrators that the club had caused its own loss by not going to Spain and seeking a stay of the Spanish proceedings on the basis of the arbitration agreement, which is a remedy it would have been granted had it made the application. It's a bit difficult to square that submission.
Seeking a stay of what? Of the arbitration?
No, seeking a stay of the Spanish proceedings on the basis of the arbitration agreement. So what actually was said in the arbitration is, you at the club could have gone to Spain, you could have obtained a stay of the Spanish proceedings brought under the regulation on this hypothesis on the basis of the London arbitration agreement. You would have won on that application for a stay because the Spanish court would have granted that application. The only reason, but this was their case, my lord, in the arbitration. The only reason, therefore, they said that you, the club, have suffered this loss is because you did not make that application, and that was a failure to act reasonably to mitigate your loss. You've caused your own loss by failing to make an application which would have succeeded, which would have meant that the Spanish proceedings would have come to an end
Well, I mean,
in
that's
favour of the London arbitration.
that is self-evidently not the case.
Well, that's what the club's case was. Sorry, that's what Spain's case was, and France's case. So your lordship says it's self-evidently not the case. That's what they said the position was. They said that they would have been bound to arbitrate had we made that application, and it was because they would have been bound to arbitrate, and had we made that application it would have succeeded in Spain. Therefore, we had caused our own loss by not making the application. So Peter Gross and Dame Elizabeth Gloucester said not so. It wasn't unreasonable conduct on the part of the club at all.
And Mr. Justice Butcher.
And Mr. Justice Butcher said that too. So what was said was that those...
Well, that's not appeal.
No. So it's quite clearly not the case that it would have been impossible to stop the Spanish proceedings because of the existence of the arbitration clause.
Sorry?
It's quite clearly not the case that it would have been impossible to stop the arbitration, the Spanish proceedings, by reason of the arbitration clause. That's what Spain said could be done.
Well, maybe they said it could be done, but it obviously couldn't.
No.
So, I mean, they may have said it.
No, with
It
great
doesn't make
respect.
it true.
With great respect, it could have been done. It was their case that it could
So
have
they
been
could
done.
have stopped it.
What actually was held is that it was not unreasonable on the part of the club not to make that application, because the club would have run the risk of submitting to the jurisdiction in Spain had that application been made. And it would have rendered in those circumstances the risk of a binding decision being made against it by the Spanish court. So, again, well, one does have to take a step back and say, well, the states can't keep on flip-flopping and changing their arguments in this way.
Well, I mean, they can flip-flop as much as they want. I'm interested in legal rights.
Yes.
And what we have to determine is whether there is a right, as a matter of law,
Yes.
to equitable compensation for breach of, which we accept happened, the equitable obligation to arbitrate.
Yes.
It is established in law that there is such an equitable obligation. It's established in fact that that obligation arose in this case. And the only question I'm concerned about is not whether they could have stopped or couldn't have stopped the Spanish proceedings, but whether you are entitled to equitable compensation as a matter of law
Yes.
for that breach. Now, it seems to me, and you've heard me say it to Miss Dilnot, and I'll say it to you, that if there's an obligation, there must be a potential, at least, right to compensation for breach of it.
Yes.
But where I'm not getting the help I need is to be told on what principles that is exercised, because you may also realise that it slightly surprises me to see the awards of the arbitrators who say they must pay every penny of your costs from beginning to end, when, anyway, as it seems to me, Spain must be able to bring, say, criminal proceedings in its own country, must be able to allow its fishermen to bring proceedings for compensation, depending on against whom, but for compensation against people, at the very least. So the proceedings in Spain are not obviously bad in any sense, and why should they pay all your costs of them, particularly when you decided not to participate mostly?
Let me take that in stages, my lord. As I've said, then there is a distinction in my submission to be drawn between the two states and the fishermen on the other.
Well, I've got that point.
You have, and the most important distinction is the one that the court has already raised, which is that Spain and France were brought to the courts of this country and in front of the arbitrator, and there were declarations made to the effect that they were obliged to arbitrate their claims and therefore not to continue in Spain. They, in breach of those orders, they carried on in Spain. And if they had not carried on in Spain, their claims would not actually have resulted in a Spanish judgment. It's not to say that the fishermen couldn't have got a Spanish judgment, as my Lady Justice Falk has already said. Then there wouldn't have been arbitration awards under Article 34.1, for example, which would be available against the fishermen, because we hadn't got arbitration awards against the fishermen, but we have got arbitration awards against the states. The vast bulk of the claims are the claims of Spain and France. Those are and not merely because they were originally the largest bulk, but also because of the fact in the case of Spain, then they paid a number of the claimants' claims and were subrogated to their rights. So when one looks at, if you like, the big fish and the little fish, then whilst it may be the case that as a matter of analysis, the position of the fishermen is the same as the position of the states, then if you look at the position of the two of them in the round, they're not the same, because we don't have arbitration awards against the fishermen, etc., which state categorically that those parties were obliged to pursue their claims in London arbitration.
So let me ask you this. Let us assume that Pablo Luis gets his judgment in Spain. Spain and France are not parties to the Spanish proceedings, but a lot of small people are.
Yes.
And Pablo Luis decides he's very cross and he's going to come, not being paid by anybody, and the fund for some reason is not enough. And he comes to London and registers his judgment against the club. And let us say the judgment is registered. There's no conflicting Article 34 arbitration award against him. So the judgment is registered and you are required to pay, notwithstanding the pay to be paid clause.
Yes.
And you bring proceedings by arbitration against Pablo Luis and say, this is a breach of your obligation to arbitrate, and I want equal and opposite damages.
Yes.
Why should you not get them?
Well, the answer is that that would be a question of discretion for the arbitral tribunal hearing that claim.
But you'd be just as entitled to have them, because the sanctity of the pay to be paid clause is exactly the same.
Well, you wouldn't necessarily be just as entitled to have them, because it might be said against you that this would be a discretionary question, not actually a question of entitlement. It might be said against you, well, you should have actually gone and stopped Pablo Luis from bringing his proceedings. You should have actually done something in order to ensure that he didn't get his arbitration award. Now,
he didn't get an arbitration award.
Sorry, his judgment. I beg your lordship's pardon. But it may be said against you. This is why I said this is
against whom?
Against
the club.
Yes.
Why? Why should the club bother? I mean, the club is saying we're totally protected by a pay-to-be-paid clause. We're certainly not going to do anything horrible against little people who are damaged, perfectly reasonably bring proceedings abroad in their own jurisdiction. But all of a sudden, you've got $1 billion of claims from 100 Pablo Luises, or maybe even 1,000.
Yes.
And they're all registering their judgments in England, And you say enough's enough. I'm not paying. Why should I pay? My contract says I shouldn't.
Can I take
And therefore, why do you not
Can I
pay?
take a little bit step back and
Yeah.
look at the facts of our case? So we don't have $1 billion of claims by Pablo Luis's. We have about $18 million of claims by Pablo
You
Luis's,
fully understand, Mr.
which
Hancock,
is
why
well
I'm testing.
within the limits of the CLC.
No, but you see why I'm testing the
No,
theory.
I understand, my lord, but the point I'm making is that you can't ignore the facts of the individual case before the court, where what you are actually considering is whether there is actually a general power on the basis of essentially unconscionability to award compensation for breach of an equitable obligation. Now, your lordships have, your lordship and your ladyship have seen, they're still not, has very fairly taken you through a number of the cases. You've seen that in those cases, then starting off with the J. Bowler, and the J. Bowler didn't say injunctive relief was the only remedy. The J. Bowler said actually that there were other remedies, but where those other remedies would not be available, because in that particular instance the action was being brought in a foreign jurisdiction which would not have recognised those other remedies, then in those circumstances the appropriate remedy was an injunction to prevent the party acting unconscionably by continuing in that foreign jurisdiction. That's what the J. Bowler rule said. But that, and the rationale for that was, as Ms. Dilnot has also very fairly said, was acting inconsistently. Consistently being claiming of the contract whilst at the same time not adhering to the terms of the contract. In the dear old-fashioned terms, seek to take the plums without the duff. And the Court of Appeal in that case said you can't do that. If actually you seek to take the benefit of the contract, you are bound by the burdens of that contract. You are bound actually by the incidents of the contract that you seek to take advantage of.
So on that principle, if, on my example, you didn't get an injunction and they did enforce against your assets in this country, you could get equitable compensation from Pablo Luis.
Yes, save for the question of discretion.
But
And
the discretion
one-
would be perfectly, I mean, there would be no reason not to exercise the discretion in favour of the club because it's
Well, it would have
it's
to
got a benefit it shouldn't have had.
It would have to be
against its conscience.
determined on a case-by-case basis. So if, for example, the individual fisherman did not know there was an arbitration agreement because the club had not told that individual that there was an arbitration agreement, then it might be said that in those circumstances that individual fisherman had not acted unconscionably. And in those circumstances, therefore, as a matter of discretion, then the club would not get its equitable compensation. But it
To
would
me,
be a
that this whole question of acting unconscionably is a gloss that you're putting on what's being said, because you don't actually find any reference to acting unconscionably in the authorities, do you? The authorities seem to suggest that it's just a failure to act in accordance with your obligations.
Well, 2 points, my lady. In a sense, the first point, your ladyship is quite right that at the stage of the inquiry where one is asking about what your rights are, then actually the cases say your rights actually are conditioned by the limitations on the contractual rights that you're seeking to exercise. Then at the stage of the remedy that is available for breach of those rights, what I was picking up on was, my Lord the Master of the Rolls' use of the word unconscionability in the context of the limits on the right to equitable compensation. And so, insofar as one is seeking a principled response to when should equitable compensation be available, it would be relevant in that inquiry, in my submission, to ask whether it is unconscionable on the facts of the individual case for the party against whom equitable compensation is sought to have exercised their rights without taking advantage, without taking account of the limitations upon those rights.
You say ignorance of the existence of the arbitration clause might be one such case.
Quite. So, and in the J. Bowler itself, I'm reminded, then what was said was said the right to apply for an injunction is not a cause of action of the same character as the right to sue for damages for breach of contract or tort or to collect a legal debt. It is an application for an equitable remedy to protect the plaintiff against the consequences of unconscionable conduct. So that is the foundation of the very principle of conditional benefit. That's to say, unconscionable conduct in seeking to take advantage of a contract without actually taking into account the limitations inherent in that same contract.
But that issue arises that whether the fisherman knows about the arbitral award or not, he is still trying to take advantage of the contract without the limitations in it, albeit that he doesn't know that he's doing it.
No, but it may be less unconscionable.
That's the problem.
It may be less unconscionable for you to seek to take advantage of a contract without taking account of limits that you do not know exist in that contract.
I mean, there are two distinctions. One distinction may be of principle,
yes,
but one is definitely not. The distinction of principle may be that these are sovereign states, but the distinction that they're little people or have big claims or little claims is not a distinction that can possibly make a difference, save as a matter of absolute discretion. So if you're looking for principles, I completely understand that part of this case is caused by the fact that we're talking here about sovereign states and you can't get injunctions generally against, so I'm not prejudging anything, but you can't generally get injunctions against sovereign states. That is a question of principle. But if we're looking, if on your case, it is right to say, and speaking only for myself at the moment, I think it is right to say that there is an equitable obligation according to law, which we can't change even if we'd like to, and that equitable obligation must potentially sound in equitable compensation in some cases.
yes,
We're still struggling, or I'm still struggling, to see what are the points of principle that distinguish it from from a contractual claim, because Ms. Dilnot made the very strong point to us. Well, everybody says this is just filling a gap, basically, because of the lack of privity, and if you fill that gap, then you have no discretion, effectively, because there is no basic principle on which you can exercise it, and you're always going to have to give the compensation to the highest degree, including costs and all these things that you got.
yes.
Now, what I'm struggling for is something beyond I mean, I'm pleased to hear that J. Bowler mentions unconscionability. That's a pleasure for us, and we didn't notice it ourselves, but now we have. But what else? Because it all looks, I mean, to my way of thinking, this is the part of it is the thing that nobody wants to talk about, is that this is created by a head-on collision between the Court of Justice on the one hand, the regulation on the one hand, and arbitration external to the regulation on the other. And obviously that circle can't be squared, but it's very uncomfortable to give a judgment for us. It might be very uncomfortable if we had to give a judgment that didn't at least give some way through that conflict.
Well, can I take that in stages? Firstly, I don't accept that there is a relevant conflict between the Court of Justice on the one hand and this question. This question actually is entirely a question of English law. It will arise in relation to direct action statutes anywhere around the world, whether in Europe or elsewhere. As my lord and my lady have already pointed out, then there are lots of countries around the world which actually include direct action statutes, whether Japan or Turkey or whatever. They're not necessarily within the EU. The second is that the Court of Justice's judgment doesn't apply really to this question of equitable compensation at all. The Court of Justice's judgment on any view had to do with the issue of whether or not the Section 66 judgment.
I know, but in its broadest connotation, it says your judgment, their judgment, can be registered in England. They assume that that's the effect of it. If we were to give it its full, I know you say we shouldn't, but let's say we did.
Well, let me. When you say their judgment, my lord, do you mean Spain's judgment or
yes?
France's?
The judgment of the Court of Justice effectively says Article 34 can't be used to prevent registration.
Yes, and my answer to that, which is the same that the arbitrator gave and the same that the judge gave, is that if the judgment should never have been procured and was only procured in breach of an obligation owed to arbitrate that claim, then what has caused the loss, which is the registrable judgment, is the very breach of which complaint is made.
Yes, but you can't then say the two are not in conflict, because they plainly are.
No, but what you can say is you can say we know which one takes precedence.
Court of Justice.
Because the only reason, yes, but Court of Justice didn't rule upon this question. The Court of Justice didn't take into account the question of whether the judgment that it was considering was one which had been reached in breach of an arbitration.
I completely understand all that, but the point I'm trying to get you to see is that one of the factual circumstances that if you were looking at unconscionability and all the circumstances of the case to decide if you should award equal and opposite damages,
yes,
is the right that the rights that the person, in this case Spain and France, bringing the claims in Spain had to do so under the regulation and the view that the Court of Justice takes about their ability to enforce it against you in England.
Yes.
Now that may not be, you're absolutely right, the legal position is not the same, the legal question is not the same, but what I want is some, to use a Latin phrase, which I apologise for because I myself say that it should never be used, a tabula in naufragio.
yes,
I want my table in the storm
yes,
to latch onto to say this is what future courts can use to decide if the compensation should run.
well, and I still go back to the point that I just made, my lord, which is that the start point is that there has been a breach of the obligation to arbitrate the claim. That's the start.
Clear. That is obviously right.
Right. If a consequence of that start point, that's to say, the breach of that obligation has led to a judgment which should not have been procured, but which is otherwise registrable under the regulation. Firstly, then the Court of Justice has said nothing about that question because it hasn't considered the question of whether or not the action should have been brought by reason of the breach of the equitable obligation which the court has concluded in this jurisdiction exists. And secondly, it would be to, if I can also use a bit of Latin, to pile pillion on ossa, to then hold that the judgment which has only been procured by reason of that breach of agreement must be allowed to remain, because the Court of Justice, in ignorance of or without actually addressing the question of whether or not the judgment should in fact have been procured because it was procured in breach of the obligation to arbitrate the claim, it can't be right to then say that the Court of Justice decision as to the judgment itself trumps the question of whether or not the judgment should ever have been procured.
So what you say is, if there is a there is a breach of the obligation that has causatively led to these foreign judgment and indeed the registration, it's nothing to the point that the Court of Justice may have played some part in that, whether it has or not. Equitable compensation lies, because otherwise there would be the injustice of people taking advantage of a contract without taking the burden of it.
Can I just go back to one point? We
Yes.
were seeing if we could distinguish on a principled basis the
Yes.
fishermen and the states. Based on what you've just said, you know, a judgment which should not have been procured, you could say that in both scenarios, the difference, if there is a difference, and whether this forms the basis of the principle, I don't know. The difference is, as you pointed out, by the time the Spanish judgments were obtained, there were specific orders, decisions, in the case of France and Spain. That is the only clear distinction I can see in what you said, because otherwise what you've said applies equally to the fishermen as to the states.
Yes, because again, what I go back to is the point that, and this really goes back to the point that my Lord the Master of the Rolls asked me when I started off dealing with the position chronologically, that at the moment the proceedings are commenced in Spain, Spain and the other parties might be forgiven for thinking that it's perfectly all right for them to begin those proceedings in Spain, which in due course leads to a judgment which the Court of Justice has now said needs to be recognised. The difference as between the position of the fishermen and the states, as your ladyship correctly points out, is that a couple of years later, then Spain and France are told that they should not be bringing those proceedings in Spain. Nevertheless, they go ahead and they continue with those proceedings in Spain, flouting the decision of this court. And
By contrast, Mr. Hancock, with damages at common law, generally speaking, one doesn't care what the state of the mind of the person is who breaks the contract. You've got a contractual obligation, you breach it, and that gives rise to causation and damage and so on. But when you're in the world of equity, it not be said that there is a difference in kind or quality between a breach of an equitable obligation, which is an innocent breach, if you like, and a breach of an equitable obligation, which is contumelious.
yes,
Very old-fashioned language, but that's what we're sort of coming down to, isn't it?
yes, it is.
You say there's a world of difference between not arbitrating in circumstances where you should, but there are other remedies available to stop you, and not arbitrating when you've been told in terms you must not you must arbitrate.
Yes, absolutely. And that's why I said actually that when you're looking at discretionary considerations, that type of consideration would be relevant, because you are actually looking at whether or not, as a matter of normal principles of equity, the conscience of the party is affected or bound by
Yes.
the relevant consideration, whereas in the case of the fisherman, it might be said, no, actually, because I didn't know that there was this obligation. In the case of the states, then they can't be heard to say, I didn't know this obligation, because they've been told that this obligation
But
exists.
yes, the better way may be to say that the unconscionable behaviour which equity may remedy is acting in the face of the arbitration award as
Yes,
confirmed by English judgments.
quite
And
certainly.
that under English law principles, that may.
Your Lordship is quite right, and in a sense, one way of testing that, which is why I tried to go through things chronologically at the outset, is that the oddity here was that at the time that Mr Justice Handlin's judgment was given, in which the declaration that arbitration had to be pursued, the next stage after that was the judgment of the Provincial Court of La Coruña. The Provincial Court of La Coruña held that the master was not liable,
Yes.
criminally or civilly. As a result of that, the owners were not liable and the insurers were not liable. So at that stage, there may have been a breach on the part of the states. That breach had not caused any loss. However, then the Court of Appeal gives judgment upholding the decision of Mr Justice Handlin. Spain don't appeal from that decision, but Spain nevertheless go ahead, Spain and France, nevertheless go ahead in Spain and thereby obtain the judgment that they now actually seek to take advantage of. So the chronology makes quite clear that it is indeed the unconscionable conduct of the states in carrying on with the Spanish proceedings and thereby procuring the Supreme Court judgment, which is, to use my Lady Justice Andrews' language, contumelious. Yes. And page 190, paragraph 199, if I can just give you the
Of what?
of Dame Elizabeth Gloucester's award also dealt with this point, because what she said was that pursuit of foreign litigation after a dispute has already been decided finally in arbitration or in court is vexatious and abusive conduct. See Masry, Michael Wilson and Emmett, and Noble Assurance against Girling Conson.
Vexatious and what?
Vexatious and
Abusive.
abusive conduct.
Masry, which other?
Masry,
Michael Wilson.
SCF.
Michael
Yes,
Wilson,
Everett.
Michael Wilson and Emmett, one of the many, and Noble Reinsurance against Girling.
Which one of the many Michael Wilson and Emmett cases is that?
I can't possibly tell.
Have you got the bundle reference?
Yes, it's
Probably number 312. What's the page? 935. 935.
page 935,
Right.
my lady, in the core bundle 2.
38.
Core supplemental.
No.
Core 2, core bundle 2, tab,
They've only got one little one. Core bundle, tab 38.
sorry, core bundle, tab 38, page 935.
Yeah.
My Lord, in essence, it's as simple as that as far as the club.
Simple as that.
With
It's jolly simple.
well, in a sense, it's a short, sharp point. You've been told you have to actually pursue your claim in one forum. You have chosen to ignore that decision that you have participated in fully. By virtue of ignoring that decision, you have obtained the fruits of a judgment which you should not have obtained the fruits of. And now actually what you seek to do is to say, I want to retain the fruits of that judgment, and what's more, you can't stop me from doing so, because it's a judgment which should be recognised under the CJEU decision.
Can I ask you about whether any of this matters, if you were right on any of the points you made before?
The answer, my Lord, and this is why I made the two short points earlier on, is if we're right in relation to the Brussels appeal, that means that the Spanish judgment, it's only the Spanish judgment at the moment, but obviously France is waiting in the wings with a potential application to enforce.
Mr. Right doesn't seem to agree about
well, I'm
waiting
just
in
going to
the
say you have to be
wings.
a bit careful. But France and Spain are in different positions. France has not applied to enforce the Spanish
Not at the
judgment.
moment, no.
It is not taking a single step in
No,
relation to
not at
that
the moment.
Spanish judgment anywhere
We're still not is
for
absolutely
5 years.
We're
So
still
we are
not-
in a different position.
is absolutely right, and I stand corrected.
I know we
The
apply for a certificate in Spain.
going back to
I said, does it matter? And you were going to tell me the answer.
that's right, my Lord. Apologies for that. The position is that, as I said a little bit earlier on, there are two ways in which it may matter. Clearly, if the judgment is not enforceable in this jurisdiction, because either under Article 34.3 or under Article 34.1, then the judgment of the English court is irreconcilable and takes precedence, then that means that in this jurisdiction, then the Spanish state will not be able to obtain the fruits of that judgment, and therefore there will be no need in that regard.
But it can enforce elsewhere.
But they can enforce elsewhere in the world. And secondly, there's the costs point.
That means, though, that on that first point, on this hypothesis that you basically don't need it in this jurisdiction, but you may need it elsewhere, doesn't it bring into sharper focus the point the Master of the Rolls was making about the, let's put it this way, tension between the regulation, direct action statutes, and the perspective of English law to characterise this as a contractual claim?
Well, it depends where else the Spanish state
Yeah,
seeks
but you're asking for an equitable remedy
yes,
with on this hypothesis
yeah,
with extraterritorial reach.
yes. But the
And in
point
fact,
I-
on this hypothesis,
I was-
that's the only thing you need, leaving costs to one side.
But the point I was going to make to your ladyship is that, in a sense, the approach of other countries around the world will differ depending upon which countries you're talking about. So, if, for example, you take countries within the common law world, they are likely to accord greater force to arbitration.
Well, yeah, but that's not quite my point. You're
I'm
asking for an equitable remedy in a rather peculiar situation where we have to recognise that English law may view things differently to other systems.
Well, indeed, the arbitration awards say that. They say it may be enforced elsewhere. Equal and opposite damages everywhere.
Damages, yes. I think the injunctive relief claim differed because I think in the end then the club did not pursue a claim for injunctive relief anywhere in the world. But in relation to damages, then they would actually rely upon their right to claim damages wherever it was that that Spain sought to enforce their judgment. What we would say as a matter of English law, and obviously we can only speak in terms of English law, is if you have an obligation to arbitrate your dispute, you have an obligation to arbitrate your dispute. So that's the end of that, we would say. One can imagine situations in which a foreign law would say, actually, under our law, it's not quite as simple as that. We therefore have to consider how this country would approach a potential conflict between.
I know, but my lady's point is really quite a powerful one. You're asking us to endorse an award that gives you free rein to get equal and opposite relief if that judgment is enforced by them anywhere in the world against your assets, irrespective of the circumstances.
Yes, we are. Of course, your lordships might, and your ladyships might consider that that would be to go too far, and therefore actually it would be appropriate for this court to deal with the situation within this jurisdiction, leaving it to other jurisdictions in other parts of the world to decide how to reconcile any potential conflict as they saw it.
And what is the principal basis that gives that result? I mean, it sounds very sensible.
Yes. Mr. Thompson reminds me he's quite right to do so. The point that is being raised is a question which goes to the discretion as to whether or not to exercise the power. The point before this court is whether or not the power exists as a matter of English law.
Yes, but it's been exercised in the most extreme possible way.
Well, but that's a question for the arbitrators, with great respect.
I think
And there's no appeal from that.
I hear all that. I do have some difficulty if it's the case that the arbitrators exercise their discretion on a misapprehension of the law. For example, they took the automatic damages because it's like a contract approach.
Yeah.
Is it really the case that we can't review that? Because normally, if a court below exercises discretion on an incorrect misunderstanding of the law, you would start again.
Well, let me take that in stages, my lady. In relation to an arbitration award, the start point has to be what permission to appeal has been given by the
I've heard all that, I know.
and in relation to questions of discretion, then in order to obtain permission to appeal under Section 69 of the Arbitration Act, what would have had to have been identified as a question of law was a misdirection on the part of the arbitrators. So effectively, if you like, Wednesbury unreasonableness, or the taking into account of irrelevant considerations or not taking into account relevant considerations, then your lordship and your ladyships haven't heard anything at all about that kind of thing, nor did the judge, because that type of point was not taken.
If the question we're being asked is what is the nature or extent of the power to award equitable compensation, I, speaking to myself, thinking about the fact that one is dealing with new waters in terms of equitable jurisdiction.
Yes.
Can't see any reason in principle why we couldn't say the extent is territorial.
Well, I suspect I need to think a little bit more about that, my lady.
I'm afraid to say it sounds a bit like the debate we've been having in Brussels on the Brussels appeal about whether it's a qualified answer to the question.
Yeah.
Because, you know, you might say that there isn't unlimited power. One scenario is there isn't the unlimited power that the arbitrators clearly appear to have thought they had to award equitable compensation, but there may be in some circumstances of unconscionability.
Yes. Mr. Thompson also reminds me, and this is why I said actually that the difficulty is with this type of question, that it may rather depend upon the country in which, or in relation to which you're asking the question. And the country in relation to which you're asking the question, and this may be me agreeing with my Lady Justice Andrews and my Lady Justice Falk, is that it may be that in the context of other countries, they might actually approach the question differently from the court in this country. And therefore may well be said that one should tread very carefully in granting relief, which on this hypothesis might actually be argued to tie the hands of...
Yes, but the problem is you didn't tread carefully and you got an absolutely swinging order from both Sir Peter Gross and Dame Elizabeth Gloucester. And so we're faced with that, and we now have to do the best we can, I know. But if we give an unqualified answer, that takes no nuance, it gives no nuance to any foreign court.
Well,
so Lady Justice Falk is putting to you
yes.
That we could say this is not an unlimited power, and there are, I mean, if, for example, you were to win on the registration point and the judgment is not registered and there is no real loss now, apart from costs, which may be something else again, we maybe need to talk about, but apart from costs, then we might say, well, we could see circumstances where this power could be exercised, but it has to be exercised on the basis of a confined discretion based upon unconscionability, and in this case there isn't any yet, or if there is some, it hasn't sounded in damages yet.
Yes.
And there are questions of causation which may be different. I'm just reminding myself of this article you sent me. What I was talking about was the difference of the rules of causation depending upon the level of fault. So strict liability as compared to negligence, as compared to willful default, as compared to fraud.
Yes.
And that's all very interesting and brought in this conflict between equitable compensation and damages. It's the same here. You know, there must be a scale on which you get equitable compensation. You can't just come along, and this is Miss Stillnot's strongest point, I would say. You can't just come along and say it's like damages for breach of contract. You get it in its full measure, whatever happens, from everybody.
Well, can I just deal with that last point, my lord, and before actually we break? Ms. Stillnot says, well, you can't just, if you like, pretend that this is a breach of contract case. And her point under that head is essentially there was no consent in this case. It's not equivalent to a contractual obligation. I do take issue with that point.
Well, because of what Lord Justice Moore-Bigg said.
Right.
But assuming that it is in fact, in this case, not a breach of contract, but a breach of an equitable obligation,
yes,
which he also said, that's good enough.
Well, but then actually, my point was a slightly different one. My point was that her point is that you have to, as it were, bear in mind that there'd been no real consent between the two parties. And my point is, yes, there has been real consent, and that's Lord Justice Moore-Bigg's point.
Yeah.
Because he says essentially by making your claim on the insurance, you thereby consent to be bound by the terms of the insurance.
Yes, I get that.
So this distinction between an equitable obligation and a legal obligation is not, in my respectful submission, a good one. That's a different point from the point that my Lady Justice Falk makes. The difficulty there comes because of the fact that, as I've said on a number of occasions, here actually then there was no appeal on this type of point.
Okay.
The states haven't ever said that the particular type of relief that was given in this case went too far. They have confined themselves to saying there's no power to give it. And so the point that my lady has raised, I think, is, well, if we think there is power, but we think actually that the power ought to be curtailed, and the terms in which these arbitrators gave the relief was too broad because of the fact that it didn't take into account the sorts of considerations that my lady has raised, then the question is, well, what do you do about that in circumstances in which that point has never been raised?
Unless you regard it as within the scope of the appeal.
Well,
okay, look, we're not going to get into this tonight because I want to draw stumps. It's 13 minutes past.
my lord, yes.
I would like to give you all some homework, please.
Yes.
Can you, over the weekend, create a new timetable for the hearings between now and Wednesday? There is a hard stop at 4:15 on Wednesday, 4:15 on Wednesday, and we will not be starting before 11:30 on Monday. I am absolutely convinced the human rights appeal should not take more than a day at the very outside. So, but it's up to you what time you want to distribute amongst yourselves. But could you give us a new timetable on Monday morning?
Of course.
And you haven't finished, so you've got time to think about all the questions that have been chucked at you on a Friday afternoon.
I'm obliged.
Yes. Okay, and I wish everybody a pleasant weekend, and thank you all for, at the very least, an extremely interesting week.
Most of it, isn't it?
Yeah, but it's because in this case, most people
That's why you moved on wrong.
the rest of the time,
Yeah, that's